Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Michael Demaray, and Michael is a highly respected estate litigation attorney in Silicon Valley. He received his JD from Hastings College of Law, University of California in 1973. His honors include the Order of the Coif. He is a certified specialist in probate, estate planning, and trust law. And among his many distinctions, he's a past president of the Silicon Valley Bar Association and a fellow of the American College of Trust and Estate Counsel. Mike is also the author of the Litigation Tools chapter of the California Trust and Probate Litigation book, published by the California Continuing Education for the Bar. And Mike is one of the people that does an annual update for the Silicon Valley Bar Association on estate and trust developments each year. Mike, thanks a lot for joining me today.
Thank you, Michael, for having me, and thank you for letting me come in my T-shirt, or my short sleeve shirt, since it's 100 degrees out there.
Okay. Anyway, so Mike is tired of cleaning up after all of us, and so the topic of today's discussion is, why don't we just live together? And so as we get into this, I just want to caution our guests to get independent legal counsel. Michael is a California attorney. He principally works on lawsuits involving estates and trusts, so he gets to see the messes regularly. Mike, is there such a thing as a common law spouse in California?
No, a lot of people think that if you've lived together with some period of time with somebody else, you become their common law spouse, that you have certain rights and duties and privileges as a result of that relationship. But California does not now, nor to my knowledge ever has had such a thing as a common law spouse. If you want to live together, you can, but that doesn't give you any particular rights.
Okay. I'm going to hope that I can pronounce this correctly. What is a meretricious relationship?
You hit it right on the nose. A meretricious relationship is one in which the parties are living together, not by benefit of marriage, and it usually implies some form of sexual liaison in return for something involving compensation, perhaps. In other words, some people think that if we're living together as husband and wife, and I'm sleeping with you and you're earning a living, that somehow I have some special status. Meretricious relationships, the term meretricious isn't used that often anymore because it implies that there's something wrong about having sex outside of marriage,
Okay.
which the courts are saying now is not is not subject of our attention.
Okay.
Meretricious, however, means that if you think that you're gaining some rights because you are having an intimate physical relationship with someone in a living and loving situation, the answer is no, you are not. That does not mean, Mike, that if you did live with someone and had an intimate physical relationship, that you would not gain certain rights, but it would not be because of the meretricious relationship.
Okay. Now, what is a putative spouse? All these cute legal terms that we got here.
It's funny, when I was drafting this, my paralegal, who's married, wrote in the word, what is a punitive spouse? And I said, no, it's not punitive, but I can understand why you made that mistake, because for many men and women, the marriage does seem like it's punitive. Mm-hmm. Putative spouse is where at least one of the parties thinks that they are legally married. The old humorous refrain was that the boyfriend promised the girlfriend that, of course, the train conductor can marry us, just like a captain on a ship. Uh-huh. Or someone married you and didn't tell you that they were also married in some other state.
Right.
And so the effect of that is that the marriage is not a legal marriage under California law. Mm-hmm. But if you are the innocent victim of that arrangement, you are the putative spouse. The other spouse that knew that he couldn't marry you because of various reasons is not the putative spouse. But the putative spouse is a special status that says, under California law, the putative spouse would get whatever the legal spouse would get in the event of a divorce. There have been cases where there are not just one, but many putative spouses. And then it becomes a bit of an arithmetic problem about how to divide up the deceased spouse's estate between the legal spouse on the one hand and the putative spouses on the other. But for example, in California law, if you die without a will, your wife gets all of your community property, or the property that would have been community property had you been married, and she gets somewhere between 1/3 and 1/2 of your separate property, depending upon whether you have children or not. A putative spouse would have that same right. Arguably, if you have an intestate situation, that is, you die without a will or a trust, you can get what's called a family allowance or a probate homestead. Family allowance is kind of like post-death spousal support. A probate homestead is the right to live in the house. A putative spouse can get those kinds of rights too. So anything that a married spouse could get, a putative spouse could get too.
So if these people both have the same rights, there must be some pretty good fistfights that happen.
I didn't quite catch that one.
Well, so he has one spouse that has these rights, and then he also has a putative spouse that has these rights. Now I've got two people that have these rights. So
that's actually a very good point. The one who doesn't have any pain from this is, of course, the dead spouse, because he's not around to see the havoc that his different marital relationships have caused between his legal wife, which is the first one he legally married, and his second or third wife, to whom he was either not legally married or not legally married because he was already legally married to someone else. Yes, they get into a fight over who gets how much of his estate.
Yeah, and now when we have this situation, the bigamist types, I mean, I guess it's apparent that there's no search that's done by people who marry you. They go to the database and they find out whether you're already married or not.
I don't know that there is such a national database. Most people are so happy to get married, they're theoretically so much in love, that they don't want to know about any bad news out there. They're certainly not going to go out there looking for it, Michael.
Okay. So we'll get into the next happy example. What is a Marvin claim?
Marvin Claim stems from a case years and years ago between Lee Marvin and his girlfriend, Michelle Triola. And Lee Marvin and Michelle had been living for, decades together. And then Lee decided he wanted to move on, and Michelle Triola sued him, claiming that somehow she was entitled to compensation for the years and years and years she spent with him. And the way it worked out was, of course, Lee was saying, well, this was a meretricious relationship. But Michelle was saying, no, I was cooking. I wasn't just having sex with him. I was cooking, I was cleaning, I was going to the Hollywood premieres. I was rendering a lot of labor, a lot of services. And I don't know if she was really paying any of the joint living expenses, because Lee Marvin was probably making enough money for both of them.
Right.
But she said I should get compensation for that. And the Supreme Court, to a very, very limited extent, agreed with her. The problem, and they allowed her to pursue her Marvin claim. The problem is proving the value of what it was that she rendered to him. And as it turned out, after 20 years of marriage, because of the nature of the services she rendered, I think she got about $100,000, which is not much to get after years of litigation. When you were living with a man that was worth millions of dollars.
Right.
So Marvin claims can be made, but financially they're not particularly lucrative to the spouse or to the partner that was not married.
Right. Yeah. Well, Lee Marvin was a very colorful character. When you look back at those old movies like Cat Ballou and so forth. But anyway, interesting. Now, and I recall reading at the time, most marital settlements, when you're married, we have tax laws that outline how that works. But we don't have tax laws that are outlined for the Marvin claim situation. And basically, as I recall, what people were saying is, it looks like this is taxable income because it's a payment for services rendered.
You're absolutely correct. Not only is, as we know right now in the United States, you can have an estate of almost more than $5 million and not have to pay any death tax on it.
Yeah.
That property that goes to the surviving spouse is tax-free. There's no income tax to the extent it didn't earn any income, and there's no estate tax on it. However, in a Marvin claim type situation, if you claim a right to compensation for your services, there's no death tax on it, or there may not be anyway. It depends upon how much you get. but there will be some income tax on it very often because, in effect, you're being paid for rendering compensation, for rendering services. Other aspects of this, too, are Marvin Claim often gets mixed up with what you might call a co-tenancy claim. In other words, if you're living with somebody and you both put money into the purchase of the house in a variety of ways. The boyfriend may have made the down payment, the girlfriend made the mortgage payments. The house was titled in the boyfriend's name alone because when he bought it, he made the down payment. And he dies, does the girlfriend have any right to get part of that house? Well, certainly she does, to the extent she can prove that her money was used to pay the mortgage or her money was used to improve the house. Believe it or not, if her money was used to repair the house, that doesn't give her any rights to the house. Repairs are something that aren't considered in the same fashion as improvements.
Sort of like a current expense or whatever.
Exactly,
Yeah.
Mike well said.
And yeah, I always wince when I meet people. Oh yeah, we moved in together. We're as married as anybody, but we're not married. And and we bought this house together. And I'm sort of gritting my teeth and clenching my.
It's a problem because the laws generally presume that the title is the correct indication of ownership. And many times you have to prove by a higher standard of proof called clear and convincing evidence that legal title is not what it should be.
Okay. Well, let's move on a little bit. We're about halfway through our interview. Can I rely on my partner's promise? Well, I'm married, so, but let's say that I'm not married, and now can I rely on my unmarried partner's promises?
Actually, I would recommend very strongly that you don't rely upon your spouse's promises either.
Gee, gosh.
The answer is no. Many times what will happen is that and you got to keep this in mind for the partner that has not got the title in her own name, the one who didn't go out and earn the income in the open market. Sometimes these meretricious relationships go on for a long time, the decades.
Yeah, some people never get married.
And the surviving partner has often gotten used to a certain lifestyle, and they've been living in the house for 30 years. And then they find out that their partner dies and has not left them anything in their will or not provided for them in any way. And they've got to uproot their life, they've got to move out, they have no savings, they have no pension plan, they've got no nothing.
Right.
And it's a very desperate situation for them. So what has happened often is that the surviving partner will say, well, my boyfriend or my partner promised to leave me his house, or he promised to leave me his cash, or he promised to leave me this. Now, can those promises be enforced? Is that promise a contract? Well, as you probably know, Michael, a contract requires not only an agreement, it also requires what's called consideration. And that's got to be legal consideration. It can't be sexual favors, as we talked about before.
Okay.
But even if you can prove that I loaned him money or I gave him money, that may well not be enough. In other words, because there's something called the statute of frauds. It was designed to say, if you're going to rely upon a promise, get it in writing. And certain things, certain agreements have to be in writing. And one of them is what we loosely call a contract to make a will. It could be a contract to make a trust. It could be a contract to buy me a life insurance policy. But whatever it is, in order for that to be enforced, it has to be in writing. There's a limited exception to that, and I use the word limited very carefully.
Yes.
If you can prove by what's called clear and convincing evidence that there was such an agreement, and you can prove not that just that you rendered consideration, but that you would be unconscionably injured, which is a very strong term, or somebody else would be unjustly enriched, you can basically proceed to prove your case. Now, what does clear and convincing evidence mean? Well, in civil court, we have basically two standards of proof. One called preponderance of the evidence, 51% to 49%, this much over that much. Clear and convincing evidence is a very much higher standard where basically there's a no doubt about it. And the reason that the standards for getting around this oral contract, this getting around the written contract requirement, is so dramatic is because, remember, after the one partner dies, there's often only one surviving witness to this promise.
Right.
And that's the one that's suing on it.
Yes.
So the courts have basically said, your word isn't good enough, usually. We need at least another witness. We need some other evidence to show that there really was this contract, this agreement, and exactly what it was. And it's not good enough to say, well, you know, I spent a long time washing a lot of dishes. That's probably not, that may be consideration, it's got value to it, but it's not what you'd call unconscionable injury. Whereas if you were the vice president of IBM and you gave up your job to be his wife full-time or his partner full-time, that would probably be considered to be unconscionable injury. But those situations are very rare. So often people file these contract and make a will claims, but they are very, very difficult to prove.
Right. And well, I think you probably see a lot more than I do, but I mean, because it's your business, and that is, you get these second a relationship after a first marriage situation. In other words, the first spouse dies, or the spouse dies, and now this person has children from that marriage, and then decides, for whatever reason, to move in with somebody, or have this person move in. They're not married, and the first thing that the kids do after dad dies is change the locks of the house.
That's what I was talking about a bit earlier.
Yeah.
I mean, you got to keep in mind that one of our biggest problems these days is our children. We generally feel, like most parents do, guilty. We haven't done enough for our children. And the children are beginning to feel that way too.
You haven't done enough for me.
They have developed a taste for a certain lifestyle that we have been able to provide for them. But the competition for jobs is so great these days, and the ability to make money is so much more difficult these days than it was when you and I were young single guys, that the children often can't provide enough or make enough for themselves to provide them with that own lifestyle. Plus they've been taught or trained or learned that they should have the right to a life. They shouldn't have to work 24 hours a day, 7 days a week like Dad did. They should have time off. Unfortunately, in a capitalist society, or in a socialist society for that matter, that kind of thinking doesn't make money for you. And so they don't make the kind of money they want to maintain the lifestyle, so where can they get it from? Oh, I know. I'll get it from Dad's estate.
Yeah.
And after all, this second woman was just his second woman. This wasn't as important to him as we were. So the fight is often between the children by the prior marriage, who by this time may be adults, 40s and 50s.
Right.
And the surviving partner, or the second wife, who could be in her 70s and 80s.
Yep.
And it can be very unpleasant for both sides.
Yeah. Yeah. Okay. What if the partner does put it in writing?
If the partner puts it in writing, it is enforceable, assuming that there's valid consideration and that you can understand what the contract is. In other words, contracts have to be specific enough to understand what it is I was going to be getting. Am I going to be getting a right to live in the house for the rest of my life? Am I going to get the whole house? What is the deal that's been entered into here? But usually if it's in writing, it is enforceable, yeah.
So it's almost like a premarital agreement, only as for a pre-living together agreement or something.
Well, are we talking about premarital and postmarital agreements?
We're going to get in, we're going to get that into the next.
We better put that off to the next session.
Okay. Okay. What is a constructive trust action?
A constructive trust action is kind of a legal term. A trust that we understand is generally what's called an express trust. Like you sign a will, you can also do it by way of a trust. And the express trust has three persons to it. The ones who set it up is called the trustor. The one who holds on to the legal title is the trustee.
Right.
And the one for whose benefit is held is the beneficiary. When I set up a living trust for myself, I'm all three. But when I die, somebody else, maybe you, take over as the trustee, and the beneficiary is often my children. That's what's called, as I said, an express trust. A constructive trust is a legal concept. Let me explain it to you. Let us say that during the time that we were living together, we did have a contract to make a will, and I did prove it. But the house, and under the terms of that contract, you promised to leave the house to me when you died. I've been living with you for 30, 40 years. This is my home. And I said, I'm moving out unless you do, and you agreed and that kind of thing. And I unconscionably relied on that. Then you can prove it. And what the court does is say, okay, even though the house is in the dead person's name, the dead partner's name, the court is going to legally construct a trust around it, in which the named trustee, who is the one that would otherwise succeed to it, your son, your daughter, your trustee, is under a duty to convey it to you. It's a form of remedy that we can say that you're entitled to. You could also sometimes sue for damages or sue for specific performance. But usually it's the house that you want. You don't want to just be compensated for your services. You want something that's more valuable than that, which is the home you've been living in. So the court constructs a legal trust around that title in your favor.
Wow, okay. What are my inheritance rights if my partner and I have been living together for more than 5 years before my partner dies?
You could be living together for 50 years and it's not going to make any difference. You have none.
None, okay.
You may have a right to a Marvin Claim, you may have a right to a constructive trust action, but those are very, very difficult to prove. And I can understand that in today's day and age, especially in the state of California, men especially, because let's face it, men still have control of most of the wealth in this country, don't like the divorce laws in the state of California.
Really?
Well, let me give you an example. Men often have, because they made more money than the women do, not always, but most of the time. Despite the Equal Rights Act, the men still get the better jobs and they get paid more. Will earn more than the wife. And the spousal support rules say that we're going to equalize that a bit for at least a period of time. If you're married for more than 10 years, you may have to pay spousal support for the rest of your wife's life.
Yeah.
And you pay it because you made more than she did, and there's usually a schedule they rely upon. But even more significant to professional men, let's say, is the fact that the laws have said your professional license, be it that of a lawyer, maybe a doctor, I don't know if it does news programmers or not, that has value to it, they say. And you might say, well, how can that have value to it? My license to practice law, I can't go out and sell it. It's not purchasable. There's no market for it. But believe it or not, through what's called capitalization of income analysis, your wife's attorney will hire something called a forensic accountant. Who will say, based upon the amount of money you've been making as a lawyer, the present value of that professional license is worth $1 million. And you might say, gee, I've never made more than $200,000 or $300,000 in my life. But those accountants get to testify. Now what the judge gets to do, and he does do it, is he gives your wife half the value of that professional license, $500,000.
Wow.
And you say, well, gee, where am I supposed to get the money to pay this from? Because I can't mortgage my license.
Well, you do have that in addition to the spousal support?
I'm getting there.
Okay.
So the wife's lawyer says, I don't care where you get it from. I tell you what, your half of the house is worth $500,000. Instead of us selling the house for $1 million and she gets $500 and you get $500, we'll let you keep your license, but you have to give us the whole house.
Oh boy.
And then the husband says, gee, that's pretty tough. But then the lawyer says, for the wife, you also have to pay a spousal support. You were married for more than 10 years. And you start scratching your head and say, well, wait a minute. The only reason I can make the money, pursuant to which I'm paying spousal support, is because of this license. So aren't you kind of doing what they call double dipping? And the answer is, yeah, kind of. That's exactly what they're doing. So this often leads men especially, again, because we make most of the money, because we have most of the opportunities, to not get married. And therefore, we avoid that kind of a dilemma. And we do.
Yeah. Well, we only really have a couple of minutes left, Mike. So I think what I would like you to do maybe is to give some final thoughts about people that are getting into these types of relationships.
Just one comment before I do, and that is if you have children in this relationship, there's no such thing as a, I'm not going to use the B word. Children are children.
Yeah.
If you're the children of a man and he's died and he hasn't provided for you, you have certain rights. If you're a minor, you have certain rights. Right to a family allowance. You have inheritance rights. just like a child that was born the product of a legally recognized marriage.
Okay.
Children have that right, and if they're minors, they've got a support right too. So usually the other partner that survives is the parent of that child, and they become the child's guardian or guardian ad litem and can sue to enforce that. But overall, it's becoming increasingly more likely that people will live together than get married.
It seems that way in our society.
Especially after they've been through one unsuccessful marriage.
Uh-huh.
And it's easier going into, but boy, for the survivor, it's a lot harder coming out of.
Uh-huh.
Whether you're romantic about marriage or not. If you want your rights to be protected, you get married.
Mm-hmm.
Of course, some of us are so lonely, and this is such a difficult society to live in now. We often like the love feeling of living with somebody.
Mm-hmm.
And that's good to have, but on the other hand, you need to be careful about what the legal consequences are to you.
Right.
And what you do with the money you make. It's not a license. If you get a chance to live with Lee Marvin, it's not a license to sit back and relax and not worried about your future anymore.
Okay. Well, folks, we're pretty much out of time. I think we'll throw one little comment in, is that you can cover a lot of these things in your estate planning documents, but the rules are not as favorable for unmarried couples as for married couples. We'll see you next time on Financial Insider Weekly.